While in opposition, the Honorable Kamala Prasad-Bissessar Senior Counsel, and now Prime Minister, recognized the increasing trend in home invasions. It was her mission and vision that there be clear and specific legislation to deal with the spiraling increase in home invasion. In keeping with its mandate to the people, the government has, within the first 3 months of office, through the Law Reform Commission, produced a draft bill known as the Home Invasion, Self-Defense and Defense of Property Bill 2025. Imagine this. It's 2 a.m. You are asleep in your home with your family. Suddenly, you hear your back door bang open. An armed man is standing in your living room, and you and your family's lives are now threatened. Under our current law, if you defend yourself and that intruder ends up dead or injured, you will be arrested. You may be charged. When you appear in court, the question would be, did you act reasonably in injuring or even killing this person? In determining reasonableness, the main factor the court would consider is whether or not you could have retreated. Yes, retreated. Whether or not you could have run. The judge must consider whether you had a duty to retreat and run away, even in your own home. That is the present state of the law. If the court believes you could have avoided harming or killing the intruder, your self-defense defense may be diminished. And I asked you, is that fair? But under the new Stand Your Ground law, that changes completely. You now have the right to stand your ground and protect your home and your loved ones. The law recognizes that your home is your castle. You acted on instinct, in fear, and in defense of your family. The law will stand beside you, not across from you. You are protected, not punished. And the message is loud and clear. If you invade a home in this country, you do so at your own risk. For the first time, it creates a distinct offense with the rights of occupants to stand their ground, clarifying when and how force, including deadly force, may be lawfully used in the defense of one's family, self, or property. This law will not allow people to kill others without consequences just for being on their property. No, that's not going to happen. The use of deadly force is only justified if the occupant reasonably believes it is necessary to prevent imminent death, grievous bodily harm, sexual assault, or rape. And in those cases, the court will consider what is reasonable, given the facts of the case. I give to you another scenario. It's just after midnight in Tunapuna. A mother is home with a 17-year-old daughter. The husband works night shift. The home is quiet. Lights are off, and the family is asleep. Suddenly, the mother hears a window shatter. She grabs her phone and quietly looks around the corner. She sees a man climbing through the kitchen window with a knife in his hand. He walks straight towards her daughter's room. The mother quickly grabs a cutlass that's kept near the back door. She hides behind the kitchen counter and calls out, "Leave my house now." The man turns, charges towards her with the knife. The mother swings the cutlass and strikes the man in the neck. He falls and bleeds out before ambulance arrives. The Stand Your Ground law will protect that mother. And that is the difference between the current law and the current state of the law and the proposed legislation. The law, as it presently stands, imposes a duty upon you, the occupier of the home, to show that your response was reasonable and proportionate. And believe me when I tell you, that is a complex legal issue to be determined. The proposed legislation removes that ambiguity. Now, one of the phrases you will commonly see in this bill is no duty to retreat. What this means is that an occupant does not have to flee their home or run before defending themselves or their family. However, they must act reasonably and proportionately. The law does not permit preemptive or retaliation attacks or vigilante-style justice. The bill, however, the bill that was circulated, goes further than the current state of the law by explicitly removing any duty to retreat, whereas the current law as it stands treats it as a factor in assessing reasonableness. Mere theft or trespass will not justify deadly force unless accompanied by a serious threat to life or limb. So this bill not only deals with self-defense and defense to individuals and occupants, but by its very name and the provisions that it sets out, also deals with protection of property. The draft bill positions in the preamble states, a person may use defensive force, including deadly force, to protect himself or his property. However, under the current situation, the current laws that are in place, deadly force is only justified in self-defense or defense of others where the force is reasonable and proportionate. Defense of property alone does not justify the use of deadly force. Under the common law, the current law, deadly force for property protection is almost never justified. What does that mean? The current law says you generally can't kill someone to protect your property, like your motor vehicle or money. Deadly force is usually allowed if your life or someone else's life is in danger. But the new legislation changes that. It says that if someone breaks into your house, you may be allowed to use deadly force, like shooting and chopping, for instance, even if it's mainly to stop them from stealing or damaging your property, not just your life. But again, you must perceive there must be a real risk of imminent danger. So it's not an arbitrary provision. It comes with built-in safeguards and protections. The bill potentially removes the nuanced balancing found in the common law and instead provides broader protection for those defending themselves or their property at home, possibly lowering the threshold for the use of deadly force. Under the current law, before using force, especially deadly force, the court looks at a lot of factors. Again, we go back to this issue of retreat. Could you have run away safely? Was your response reasonable? Was the threat real and immediate? And these are questions that are asked. These are questions that are asked by the court, and the burden is upon you to show that you acted reasonably under the current state. So this is a balancing act, and the court tries to judge if your actions made sense in the moment. That is tremendously difficult. The bill makes it simpler. If someone breaks into your home, you don't have to stop and think about running away. The law gives you more freedom to defend yourself and your property, even with deadly force. The bill takes into account practical situations. So that if you look at clause 9 of the bill, for instance, for example, if you help your neighbor during a home invasion, you will be protected under this law. And that is very important for a small society like ours. You're always your neighbor's keeper, right? The bill also has safeguards to prevent the law from being abused. So you cannot use it to cover up or make an excuse for injuring or even killing someone. The bill sets out strict conditions and exceptions where the defense would not apply. Example, if the force used was grossly disproportionate, or if the person was engaged in criminal activity at the time, that is the occupant, right? And these exceptions can be found in clause 10 of the bill. Now, some persons are of the view that this new bill may not be necessary because the protection that it affords already exists in law. And that is not necessarily correct. It recognizes a specific offense of home invasion. It defines home invasion as a specific criminal offense with unique elements, including unlawful entry, combined with the use or threat of force, intimidation, use of weapons, or commission of grievous offenses, example, rape and grievous bodily harm. It also introduces aggravating factors. For example, if someone who is committing the offense is a member of a gang, if it is done in the presence of vulnerable persons, like minors and elderly persons, in those cases, there are increased and harsher penalties. While the Larceny Act, that is a present act in force, covers various offenses like burglary, housebreaking, and robbery, it does not treat with home invasion as a distinct offense. So the proposed bill expands protection for occupants. It grants the same defensive rights to people acting in aid of an occupant or at their direction. It covers curtilage and associated areas of the home, that is the areas immediately surrounding the home, such as the yard, garage, and other elements such as a motor vehicle or a boat, which can be considered as a dwelling. In the stand your ground law, you have the penalty being $500,000 with 20 years imprisonment, and if there's an aggravating factor, such as the act being committed in the presence of a vulnerable person, such as an elderly person or a minor, or the act is being committed by a member of a gang, then in those cases you have an increased penalty of 25 years in prison and a fine of $750,000. So what I have done is taken you through the bill itself. It's a very short bill, but very important bill, and I've tried my best to take you through the main provisions of the bill and how is it different from what currently obtains as opposed to what the government now proposes to implement. So with that, I would pass you on to the chairman.